Good afternoon, everyone. May you take a seat. Welcome to the event, Understanding Transnational Repressions. And I'm happy to say thank you to our host, member of Parliamentary Assembly of Council of Europe, Mr. Konstantinos Eftatou, who will open our meeting.
Thank you. First of all, I would like to welcome a good friend of mine, who is a lawyer, prominent lawyer in Cyprus, Mr. Dimitriadis, who is here. He's well known for his devotion on human rights, and it's an honor for us to have him here with us, together with the ambassador of Cyprus. Thank you, sir. It is a great pleasure hosting this event here in the Parliamentary Assembly of the Council of Europe during our winter session. I would like to thank you all of you for being here today and your interest in this important discussion. Transnational repression is no longer a marginal or isolated issue. It has become a growing and systematic practice used by authoritarian regimes, but unfortunately not only by them, in order to extend repression beyond their borders and to target political opponents, journalists, human rights defenders and their families abroad. What makes this phenomenon particularly concerning is that it often operates through the misuse of international mechanisms that were originally designed to promote cooperation, justice and the rule of law. As rapporteur of transnational repression, I'm currently working together with a large and committed team on a report that aims to map these practices, identify recurring patterns and assess the institutional vulnerabilities that allow such abuses to occur. This work is still ongoing, and this is precisely why events like today's are so valuable. They allow us to bring legal analysis together with lived experience and institutional perspectives together with concrete cases. Today's discussion will bring together testimonies, expert analysis, and country-specific examples that can directly inform parliamentary work. I'm confident that this exchange will contribute meaningfully to the report and to our collective understanding of how democratic institutions can respond more effectively to transnational repression. With that, I'm very pleased to open this event and to hand over the floor to our moderator, Anna Sachi, from Brussels, representing the Peace and Justice Platform, which is the co-organizer of this event. Anna?
Thank you very much. Thank you, Konstantinos, for these opening remarks and for your leadership on this report. As moderator, I'm pleased to open this discussion as well and to briefly set the framework of today's event. We will examine transnational repressions through a series of concrete cases, country cases, combining expert analysis with direct testimonies of victims in order to illustrate how the phenomenon operates in practice and how it affects individuals and families across borders. With this in mind, let us begin our discussion. And I'm pleased to welcome our first speaker, Pavel Latushko from Belarus. Pavel is a member of the delegation of Belarusian Democratic Forces to PACE, a member of the Coordination Councils of Belarus, and a prominent human rights defender, victim of transnational repression himself. Pavel, the floor is yours.
Thank you so much, Mr. President, colleagues. I see it is my task today to reveal the circumstances of the extraterritorial persecution of Belarusians, which could be the largest case of transnational repression in Europe. Slide number 1. In 2020, following a fraudulent presidential election, Alexander Lukashenko regime launched an extensive campaign of internal repression. Its goal, articulated by the dictator himself, was to cleanse Belarusian society of all deemed disloyal. For years, these actions went unpunished, leading to tens of thousands of arrests and imprisonments, and ultimately to mass expulsion and further extraterritorial persecution of those the regime considered disloyal. Slide 2. According to the 2025 report of the United Nations Group of Independent Experts on the situation of human rights in Belarus, up to 600,000 people have left. Slide 2, please. Up to 600,000, slide 2. Back. Come back. From the beginning, please. According to the 2025 report of the United Nations Group of Independent Experts on the situation of human rights in Belarus, up to 600,000 people have left Belarus since 2020, representing 6.4% of the population at that time. The overwhelming majority of those targeted fled Belarus because of repressive conditions and oppression. The UN Group of Independent Experts confirmed that people left due to a well-founded fear of arbitrary arrest, detention without a fair trial, torture, threats of child removal, and restrictions on the right to work and access education. Nearly all victims interviewed reported that they had no genuine choice but to leave. In addition to creating oppressive conditions, the regime actively resorts to direct physical deportations. The expulsion of political prisoners is a striking example. On the screen you can see a direct quotation from one of the victims. Slide 4. I would like to once again underscore 6.4% of the population. This is an unimaginable figure, representing an irreparable demographic loss for our nation. Forced expulsion from Belarus is not the end of the suffering for those targeted, but the beginning of transnational prosecution by the regime. These repressive actions affect everyone who has left Belarus due to political persecution or the fear of such persecution. Human rights organizations documented that these abuses intensify each year and today affect nearly all Belarusians expelled from the country. By 2023, Belarusian consulates has stopped issuing and renewing passports, leaving hundreds of thousands at risk of de facto statelessness, along with other essential documents, such as powers of attorney for property transactions. As a result, those targeted are deprived of the ability to travel or live a normal life abroad. Already, dozens of children have been born without the ability to obtain a passport. The regime have also launched a campaign of judicial harassment, using trials in absentia to persecute Belarusians abroad who speak out against Alexander Lukashenko's regime. By December 2025, hundreds of criminal proceedings have been opened against Belarusians in exile, with at least 200 trials conducted in absentia. These trials typically violate fair trial standards, and with most independent lawyers in exile, disbarred, imprisoned or silenced, almost no one remains to defend the accused. Individuals face constant fear of being placed on Belarusian wanted list and risk detention or deportation when traveling. The regime even abuses Interpol's red notice system to pursue political motivated cases. Sentences can be draconian, reaching up to 20 years of imprisonment, often simply for exercising fundamental rights, opposing the regime's atrocities or supporting those persecuted. At the same time, Belarusian authorities intimidate and silence the diaspora, threatening individuals and their family members in Belarus, monitoring them abroad, and creating an atmosphere of fear to discourage Belarusians from speaking out. Transnational repression has become a systematic tool used by authoritarian regimes to pursue their opponents beyond national borders. However, the Lukashenko regime has taken these practices to a scale that meets the definition of persecution as a crimes against humanity, over which the International Criminal Court has jurisdiction. Impunity has been one of the key drivers enabling the expansion of these repressive practices. Will justice remain blind and silent? Thank you.
Thank you very much, Pavel. Pavel, thank you very much. Really touching numbers, and unfortunately, we will speak today also about Turkey, which is samely reaching the level, so the repressions are reaching the level of crimes against humanity. And this is in the 21st century when the civilized people still hope to live in another better world. But now I'm pleased to introduce our next speaker, a very good friend of ours and a prominent human rights defender. His personal story is deeply moving, but even more powerful is his long-standing work in the field of human rights. Mehman Huseynov is with us today, and he will speak about Azerbaijan.
Thank you, Anna. Dear colleagues, dear friends, I hope you hear me well. In Azerbaijan today we have no freedom of speech or freedom of assembly, no independent journalists, media workers and activists, everyone in jail. More than 400 political prisoners. Recently, government decided to arrest last opposition leader Ali Kerimli with fake, fabricated, politically motivated charges. Currently in Azerbaijan authorities start to use very oftenly their own legal system as a weapon of war against the critics and activists in exile. Since March 2025, the General Prosecutor Office opened 24 high-level profile cases against critics and human rights defenders in exile. They launched a massive wave of criminal proceedings in absentia. I can tell you like a few people's names like lawyer Subhan Hasanli, Ayta Jaghazada, scholars like Altay Goyushov, Arastu Nurojlu, journalists Sevinç Osmangazi, Ganimet Zahidov, all of them living in political exiles, very popular critical bloggers and public figures like Tural Sadıklı, Gurban Mammadov, Elshad Mammadov, Süleyman Süleymanlı, Orhan Agayev, Imamadin Alimanov, Rafael Piriyev, Orduhan Temirkhan, Abid Gafarov, our colleague is just here with us today. Another Vagif Allahverdi, Beydullah Manafov, Murad Guliyev, and Manav Jalilzadeh, Elshad Abdullayev, former officials and whistleblowers like Arif Mammadov, Ilgar Ajiyev, very well-known entrepreneurs who also live in exiles and provide lots of whistleblower documentations on grand corruptions. Many of them today already received judgments by Azerbaijani court for long-term prison detention. They are still in exile, but it's a risk for the government able to use Interpol and other international mechanisms for extradite them to Azerbaijan and punish them there. Today, I can speak a lot about these cases, but I would like to highlight cases with attempts of the life, when government kills there illegally. There, for example, this is legal tools, which is I'm briefly described, but another serious issues when they try to hire like a killers and kill their opponents in exile. For the few years, we already fixed 4 cases when government killed their opponent and critics. Cases like Muhammad Mirzali, he lives here in the city of Nantes. He received 4 attempts of his life against him. Vidadi Iskandarli, unfortunately, can't survive. After the last attempt of his life, he's died after 29th attack. He's murdered in his own apartment, and he received political refugee status here in France. And other cases, like when we able to cover some mysterious deaths, like bloggers Hüseyin Bakirkhanov mysteriously killed in the Georgia, and Georgian government not make proper investigation. According to Aftandil Mammadov, our colleague, which is still in political exile in Georgia and have also trouble for investigating this case, Georgian government denied to make effective investigations, unfortunately. They also use like illegal Azerbaijani diplomatic corps representatives in Georgia. They kidnapped, for example, very well-known journalist Afgan Mukhtarli and bring him to Azerbaijan. Another case, Bayram Mammadov, found dead in Turkey, in Bosphor. And many cases, like when we find Vugar Zaev, also found like in the water channel in the European capital, in Belgium. And unfortunately, Belgium authorities also not properly investigated this case. So today we have another alert, very serious alert with our colleague, and he's also my brother, Mehman Huseynov. He spent like several years in Azerbaijan prison. Now he's living in exile. And I would like to finish with after his recent investigation regarding ruling family members, including President son Heydar Aliyev and his daughter-in-law Alyona Əliyeva, which is currently we are recognized for she is like Ukrainian citizen. My brother and our family members, including me, we start to receive live threats against us. And we would like to highlight we can continue our fight for democracy, human rights, and expose grand corruption until in country which is Azerbaijan is member of the Council of Europe, we don't have free and fair elections. We have all fundamental freedoms which is described in European Convention for Human Rights. I thank you, your colleagues, if you have questions, we're glad to respond for this. And we are alarming again for all Council of Europe member states, especially Germany, France, Switzerland, which is recently we received these attacks against political refugees. This case shows for international protections and conventions which is protected refugees not working anymore, and we need to think about new mechanisms to increase international protections for outspoken voices, and especially in the Council of Europe member states. And especially thanks for Rapporteur to give us opportunities to deliver this important message.
Thank you very much, Emina. I'm sure at the moment of question and answers, there will be question on Azerbaijan. But at this point, we will turn to Turkey, which is, I would say, the most difficult area of our work, and unfortunately the largest source of examples of transnational repression carried out particularly dangerous and increasingly in their sophisticated way. A significant number of Turkish and Kurdish cases have been documented and analyzed in the framework of this report. And the regime of Erdogan is giving us everyday lessons from where we need to learn how to better resist in front of transnational repressions, kidnappings, forced disappearance, arbitrary detention, practices that many experts qualify as amounting to crimes against humanity, as well as we know the situation about Belarus. But now I'm happy to transmit the floor to our expert in Turkey, Mrs. Ceren Yüksel. She is a prominent human rights defender and an expert on this topic. And the floor is yours, ma'am.
Thank you, Anna, and thank you, Rapporteur, for this invitation and for giving us the chance to discuss this very important topic. First of all, I would like to say that I will use examples from Turkey, but I will not focus on what Turkey is doing, because I believe that everybody in this room knows that Turkey has a very clear dictatorship. Some of us are calling it beyond this, but I will not repeat. But I will focus on the effects, the impacts of Turkey's practices within the Council of Europe. I think this is much more important for us today to see how Turkey's practices are affecting the established rules of the Council of Europe and all the other European systems that we know. So what we are discussing here is straightforward, the ability or the skill of a state to extend its repressive reach beyond its own jurisdiction by having its pressure exercised through the asylum, border, security, and judicial mechanisms of other states. This pressure might be physical in some cases, as we heard, but especially in Europe, it is not the most common practice. It operates primarily through the legal and administrative means. And precisely for that reason, it raises serious concerns under international or European context, human rights law. I will focus on three specific areas today: the use of foreign intelligence in international protection mechanisms, the impact of this practice on the right to a fair trial and effective defense, and the third one is the restrictions on freedom of movement, including Schengen bans and the misuse of international police cooperation mechanisms, and, of course, as a result, the criminalization of political identity. International protection law is grounded in two core principles: non-refoulement and the right to an effective remedy. Any assessment of a risk of return must therefore be transparent, accessible to the applicant or the representative, and capable of meaningful judicial review. However, in a growing number of cases right now in Greece, in Switzerland, in Germany, and unfortunately in other European states, particularly those involving applicants from Turkey, we see a different practice. Information originating from Turkish intelligence services, namely MIT, is introduced as confidential security material and used to suspend, review, or threaten the withdrawal of protection status. This information is not disclosed to the applicant, is not shared with their lawyer, and cannot be substantively examined by the court. And this is the question: how can a person defend themselves against allegations they are not allowed to know? Last summer, we had one very significant example in Greece, which is one example. I would say there are hundreds of cases in Greece like that. We know this case because the applicant was a lawyer who is also a member of our association, European Association of Lawyers for Democracy and World Human Rights. And his protection status was under review, again, because of some secret reports that were received from Turkey. He got a positive outcome after the judicial review, but unfortunately not because of the effective remedies, but because of the international legal organizations' huge pressure and his own political action. He started a hunger strike. But unfortunately, hundreds of Kurds in Switzerland, in Greece, in Sweden, in other countries, they are now under the same risk. I will not disclose the name here today, but one of the former lawyers of Abdullah Öcalan right now in Sweden is dealing with the same situation. So, you know, these are not exceptions. And this illustrates a very structural problem. Legal safeguards tend to function only when there is visibility and political pressure. Many other activists who are not publicly known remain for months, sometimes years, under constant fear of removal. The case of Kenan Ayaz is another clear example of political detention and transnational repression under a European guide. Kenan Ayaz is a recognized political refugee in the Republic of Cyprus, a status that has never been revoked. He was convicted in Germany for participation in a terrorist organization, despite the fact that the acts underlying this conviction consisted exclusively of peaceful political activity, such as participation in demonstrations and cultural events. No act of violence or criminal conduct was established, and none of these acts would constitute a criminal offense under Cypriot law, and I would say under many other European countries' law. Following his arrest, the courts from the Republic of Cyprus demanded formal guarantees from Germany, and on that basis, Germany allowed him to be back in Cyprus, but he's still in prison serving his sentence, which is not an obligation under Cyprus law. Cyprus had the chance to release him, but they didn't. So I think here what we need to focus on, how Cyprus, or in the other case Greece or other European countries, effectively transfers Turkey's repression into the European legal space. And I think this should be the problem that we need to focus. The other problem that my colleague mentioned is very much related to fair trial rights, judicial scrutiny, and international policing. When courts or administrative authorities accept intelligence material without examining its source, the political context in which it was produced, or whether it serves purposes of political repression, judicial scrutiny becomes purely formal. This problem is compounded when international police cooperation mechanisms, including Interpol alerts and related information sharing practices, are treated as neutral or technical signals rather than as potentially politically motivated inputs. I will not give examples. Turkey did millions of attempts to misuse such mechanisms. And of course, this affected a lot of individuals, especially the political individuals' right to right to access asylum mechanisms, etc. And the third issue that I want to slightly mention is the freedom of movement and mobility restrictions. There are three very important examples in this sense. One is, for instance, the president of the European Association of Lawyers for Democracy and World Human Rights is an Italian lawyer, Barbara Spinelli, who cannot travel to Turkey since 2017 because of his activities as a trial observer in Turkey concerning the cases against the Kurdish lawyers, and also her participation as a fact-finding mission observer in the Kurdish area when we had the non-stop and completely unlawful curfew, and in 2017 she was banned from Turkey. And another example is again related to the colleague that I mentioned, Günayda. Yes, now he has his legal protection status, but he cannot travel within Europe because Italy decided to put a Schengen ban. The funny thing here is he never and ever put his foot in another European country than Greece. There is no reason for Italy to put such a Schengen ban. This is the second example. And the third example is sitting in front of me right now. One of our other friend, Oscar Ahan, was also declared persona non grata for allegedly acting against the national security of Turkey, and under law G82 of the Turkish state. So I'm just coming to the conclusion here. I think these examples point to a broader reality, and I think we can start talking about tens of them. Transnational repression is no longer an exceptional device, exceptional tool of states. It risks becoming a normalized practice at the intersection of asylum law, security law, international police cooperation, and border control. And this problem is not individual decisions. The problem lies in the sources relied upon, the absence of procedural safeguards, and the cumulative erosion of the fundamental rights. When international protection, freedom of movement, and legal status can be restricted on the basis of undisclosed intelligence and transnational policing practices originating from the repressive state, we are no longer dealing only with individual cases. And when that happens, it is not only the rights of refugees or the political activities coming from other countries. I think it is the credibility of Europe's democratic and legal commitments themselves. Thank you very much for the opportunity.
Ceren, thank you very much, and thank you for your courage and impressive work in this field. Don't stop. We need people like you. And dear colleagues, I think we need to hear not only experts, we need to hear voices. I would be happy to never have in such a room a victim of transnational repressions, but unfortunately they are amongst us, and we thank them for courage to speak and to show on their example how deep can go transnational repressions. Continuing the Turkey topic, I would like to give the floor to Bayraktar Hussein, a victim of transnational repression who've been kidnapped 7 years ago from the country where he was in asylum, and he was brought to Erdogan prison, where it took us big teams of human rights defenders 7 years to get him out. Bayraktar, please share with us your story.
Thank you so much. Herkese saygıyla selamlıyorum.
3 minutes.
He knows. He knows.
Salute everyone.
Yes.
Respect. Ben de Türkiye'de, daha doğrusu Türkiye'nin bir etkisiyle negatif yönde bir problem yaşadım.
I'm a victim of such a problem in the past.
Anna Hanım'ın söylediği gibi ben de Moldova'da bir özel okulda öğretmenlik yaparken 2018 yılında maalesef bir kaçırılmaya maruz kaldım.
I was subject of abduction in 2017 when I was working at a private school. 2018.
Ve 7 tane meslektaşımla birlikte Moldova'dan Türkiye'ye gayri resmi yollarla maalesef kaçırıldım.
Together with other 7 colleagues, a total 8 teachers, we were abducted from Moldova to Turkey.
Ben diğer arkadaşlarıma göre şanslıydım. Toplamda 26 ay cezaevinde kaldım ve sonrasında özgürlüğüme kavuştum.
I was lucky compared to my other colleagues. I served in prison for 26 months and then released.
Özgürlüğümü elde ettikten sonra tekrardan fırsatını bulunca komşum Yunanistan'dan tekrardan özgürlüğüme kavuştum.
After discharge, I fled the country for Greece, and then I got my freedom again.
Burada dikkatinizi çekmek istediğim konu şu, Türkiye'nin maalesef sadece ülke içerisindeki değil, yurt dışındaki de negatif etkileri çok fazla.
I just want to underpin that practices, such kind of ill practices are not limited in Turkey, but also this extends outside Turkey.
Bu yüzden Moldova'dan gayri resmi olarak kaçırıldım.
Therefore, I was evicted from Moldova to Turkey.
Umarım benim başıma gelen şey bundan sonra başka bir insanın başına gelmez ve bu problemler en kısa zamanda son bulur.
I hope what happened to me does not happen to another human being, another friends or whatever in the future.
Teşekkür ederim.
Thank you.
Thank you, Bayraktar. Thank you very much. And unfortunately, post-Soviet countries are big friends of, most of the post-Soviet countries are big friends of very well-known perpetrators like Erdogan. In post-Soviet countries, transnational repression is living like at its home. We move slowly to this area, to the post-Soviet countries, and I'd like my colleague to help me putting a video testimony, apart from the video interview of the Jamila Imbetova Tokmadi. She's speaking about her husband who's still in prison and whose case served for multiple abuses of Interpol. After he was tortured, he was obliged to sign false testaments against opposition abroad. So this is a transnational repression in its sophisticated way. Here are 50 seconds of what Jamila is telling about her.
Один раз мы избили 20 сотрудников вот этой... Ну, например, один эпизод. Привязывают вот так закованного человека в наручниках в трубе и вот так берут металлические такие шары в голову кидают. Один раз мы избили 20 сотрудников вот этой службы Арслан, или как там называется. Потому что, за что спросить? Потому что он хотел написать письмо президенту, ручку попросил. Он 3 дня лежал, встать не мог. У него переломаны ребра, у нас есть, причем экспертиза, лишение сна, вот это постоянный свет, там, вот все, это мелочи вообще. По несколько дней не давали спать специально, чтобы в таком состоянии лежать что-нибудь. И ему показали фотографию наших детей в Польше. Сказали, мы за ними следим. Джамилю по 3 уголовным делам мы закроем на 15 лет, а дети в детский дом. Все, вот после этого он подписал процессуальное соглашение.
Yes. So this is Kazakhstan. We have Jamila in the room now, but she asks not to speak because of re-traumatizing. Kazakhstan, it's a big example of post-Soviet countries where transnational repression is, as I said, at its home. But the most harmful and the most disappointing for us who are coming from this part, which is Eastern Europe, is that countries like Moldova and Ukraine, which were promising more democracy and being closer to European Union, are still facing cases of lack of fair trial, things against rule of law, and abusive use of mechanisms of international cooperation and Interpol. We will have with us in a few seconds, I'm establishing connection, the former ombudsman of Ukraine, Valeria Lutkovska. She will speak about hate cases connected with Ukraine, but unfortunately we have a case which already had been part of the study in the report of under the auspices of Mr. Konstantinos. And I know before we established the connection that Mr. Konstantinos was so brave that he even attended a court hearing in Kiev nowadays in this situation. Konstantinos, may you tell us a bit more about this case so I can, after that, speak with Mrs. Lutkovska?
Yes, I had the chance to attend the trial of Mr. Alexander Granovsky, if I'm okay, who is a typical case of international pressure. He had a trial in Kiev, and I was astonished by the fact that despite the lack of evidence against him, and despite the fact that the prosecution and members of the judiciary admitted that the documentation against him were forged, technically forged, he is under very threat of being convicted, and expelled from England to Ukraine to serve his sentence in case of conviction. This is a typical case of how the legitimate and legal proceedings can amount to international repression when these are abused by authorities. And unfortunately, this is the case of Mr. Granovsky.
Mrs. Lutkovska, can you hear us?
Yes, I'm here. Thank you.
Thank you very much for being with us. I know that there are also documented evidences of pressure exerted by the director of NABU, and there are documented evidences of non-procedural communication between the prosecutor and the judges, simply saying political commands which were transmitted to the judges. Can you elaborate more on these phenomena in Ukraine, which we were very much hoping that we left behind in countries like Ukraine and Moldova, but seemingly is not. We hear you, Ms. Lutkovska.
Okay, thank you very much. Good afternoon, dear participants, dear chair. I am sincerely grateful for the invitation to today's event and for the warm introduction as a speaker. Today I represent the interests of civil society in a country that is in an extremely difficult situation. War is raging in Ukraine, and war for every Ukrainian, for our right to self-determination, for the existence of an independent Ukraine and independent Ukrainians. Unfortunately, as human rights defenders note in their annual report, in particular the Kharkiv Human Rights Group, another war is raging in Ukraine, an internal one. And it is a war waged by the authorities against their own citizens. Today the following have become widespread in Ukraine: political persecutions through the abuse of criminal justice mechanisms, extrajudicial sanctions, including against Ukrainian citizens, deprivation of citizenship, restrictions on the ability to defend their own rights and to express their positions. There are many examples. The case of former head of National Bank of Ukraine, Kirill Shevchenko, sanctioned against the fifth president of Ukraine, Petro Poroshenko, political persecution of one of the opposition leaders, Yulia Tymoshenko, and other cases. I would like to focus in a very telling example, the case of Alexander Granovsky, who was a colleague of Petro Poroshenko and belonged to the previous political team. It is precisely because of this that he became the target of politically motivated criminal prosecution. The case began when the former head of the president's office met with so-called anti-corruptional activists and promised them that criminal proceedings would be brought against Granovsky. In other words, from the outset, the case was of a custom-made nature, with criminal proceedings being sought against a specific individual. Like any political persecution, This case quickly became riddled by numerous human rights violations, which will undoubtedly on one day be considered by the European Court of Human Rights. I have received a number of documents from Mr. Granovsky's lawyers, analyzed them, and I was frankly shocked. You are probably aware that in Ukraine, criminal proceedings against high-ranking officials are investigated by the National Anti-Corruption Bureau of Ukraine. In this case, the criminal prosecution was preceded by meetings of a meeting of NABU detectives in which they directly point to pressure exerted by the director of NABU, who demanded that a notice of suspicion be served to Mr. Granovsky, despite the absence of any legal grounds for this. The detectives clearly record this fact. Moreover, they address the director of NABU with a demand to return to the legal framework. In an independent judicial system, such a case would be doomed to failure. But when the judicial system is under the pressure from political forces and so-called activists, it is difficult to hope for a fair trial. The essence of criminal prosecution of Mr. Granovsky is that, as a people's deputy, he gave a recommendation to a person to join the board of directors of a large enterprise. And in this, Ukrainian law enforcement officers saw a criminal punishable act for which the criminal code provides for a real term of imprisonment. I understand that such an explanation of the criminal prosecution may cause genuine surprise for an independent observer. Therefore, in confirmation of the fact that this is how the Ukrainian justice understands the crime, I quote the decision of the Appeals Chamber of High Anti-Corruption Court. Even witness statements about Granovsky's involvement in a criminal offense are sufficient to establish the existence of reasonable suspicion, given that there is no reasonable explanation as to why a member of parliament, whose functions relate to legislative matters, was involved in forming the governing bodies of a state-owned enterprise. This issue clearly falls outside the competence of legislators. We all understand what a recommendation is. Each of us has given and received recommendations. A recommendation is not a crime anywhere in the world, except, unfortunately, in modern Ukraine. The case record shows the following. Illegal communication between judges and the prosecution. Falsification by NABU of the results of covert investigative measures. Attempts to use these falsified materials in the court. And the subsequent refusal by the prosecution to rely on these materials after convincing expert examinations submitted by the defense. However, even after this, the court did not change its position of the alleged grounds for the notice of suspicion against Mr. Granovsky. He remains a suspect and, as of today, is already an accused person in a case that is absurd in its very essence. Unfortunately, Interpol was also involved in the case. Interpol is an organization, international organization, intended to ensure that no guilty person avoids responsibility, but which, under Article 2 of its constitution, states that it carries out its activities with full respect for human rights. But in the case of Alexander Granovsky, Article 2 of the Interpol Constitution does not operate. I will explain why I am entitled to make this statement. In particular, in this case, Interpol used the procedure of communication with the National Central Bureau of Interpol in Kiev and received answers to its questions. These replies provided to Interpol were analyzed by Ukrainian courts. I will allow myself to quote some of them. The National Center Bureau of Interpol informed the Interpol Commission for the Control of Files that lawyers of Mr. Granovsky had never complained about political persecution in Ukraine. But even investigating judge of High Anti-Corruption Court of Ukraine, Judge Borenko, in his ruling of 11th of December 2024, expressly refuted these statements, noting that National Center Bureau of Interpol had provided false information to the Commission. So I quote, the National Center Bureau of Interpol in Ukraine stated that Mr. Granovsky and his lawyers had never filed any complaints regarding his political persecution. These statements are untrue and are discovered by the documents attached to the application. Further, the National Center Bureau of Interpol claims that Mr. Granovsky had received an unlawful benefit because of Petrol Holding Corp allegedly used the same IP address as his office. The ruling of investigating Judge Borenko of 14th of January 2025 fully refutes the information sent by National Center Bureau of Interpol to the
Mrs. Lutkovska, thank you very much. Unfortunately, we are a bit running of time, but the most important, I would like to make connection with everything what you've said, with the members of parliament that are attending here, and they will have the floor from the room, and especially since we have members, politicians from France, where Lyon, Interpol is having the headquarters. And I would like to transfer the floor to the French MP about that, but please remain without us. And I would say that all these cases that we've been speaking today are part of the work, of the impressive work which Konstantinos Evstatoiou team are doing, and we will continue with this report. Stay with us. Thank you very much. We have Emmanuel Fernandez in the room. Mr. Fernandez, bonjour. I give the floor to you. France had been mentioned and Interpol.
Bonjour. Bonjour Anna. Bonjour à toutes et à tous. Effectivement, Interpol a été beaucoup mentionné. Interpol a son siège en France à Lyon. Et Interpol est censé être un instrument neutre de coopération policière internationale, facilitant l'échange d'informations pour lutter contre le terrorisme.
Operation to fight against terrorism, cybercriminality, and large-scale criminal organization. However, through various reports from the website disclosed, it shows that the repressive regimes abuse Interpol red notices and other mechanisms of Interpol to other ends. So Interpol is not immune to serious abuse. For instance, red notices are centralized on a website, and it's a tool that's often used as a tool to harass journalists, activists, opponents, rather than to track down dangerous criminals, which is really contrary to the internal rules of Interpol. Example in France is the Franco-Turkish Pinar Selek, researcher who has been accused of trying to plot a terrorist attack in Istanbul, which never took place. And the Turkish justice acquitted on 4 occasions Mrs. Citrick. However, this person is still under the request of an arrest warrant. It's a symbolic case of a typical judicial harassment against a person because she's deeply committed to the human rights of minorities in Turkey, such as the Kurdish people. So Turkey continues to misuse these tools to extend and prolong the repression against this person. This shows that Interpol has structural weaknesses which can be instrumentalized by governments. Interpol does not have a transparent mechanism of sanction against states that request abuse the mechanism. So it is urgent to reform Interpol.
Des défenseurs des droits humains, il faut instaurer une supervision indépendante, transparente et des recours rapides pour les personnes injustement ciblées et enfin appliquer des sanctions claires aux États qui abusent du système car sans ces réformes, Interpol pourrait devenir un outil de répression transnationale plutôt qu'un instrument de justice internationale. Merci.
Leave meeting together.
Thank you. Thank you very much, Emmanuel. Hope France will not repeat mistakes of complying with authoritarian and dictatorship regimes. And since we have a wide geography, unfortunately we have a wide geography about transnational repression, I would like us everyone to hear the message from Bill Browder, who was here at this session and kindly left us a video message. Bill Browder, the author of Magnitsky Law, had been also a victim of transnational repression.
Hi, I'm Bill Browder. I'm sorry that I'm not physically with you today. I had to leave day before yesterday from Strasbourg. But given the importance of today's event, I really wanted to at least share with you a few of my own words. As being a victim myself of transnational repression, I know how pernicious this whole issue is. In my case, the Putin regime has been chasing me for 15 years. They've issued 8 Interpol arrest warrants for me, 12 mutual legal assistance requests from the British government for my extradition and other nastiness. They've been suing me, they've been chasing me, they've been surveilling me all over the world. So I understand this is an absolutely crucial issue. And this is an issue which most governments aren't paying attention to. And this is an issue where when you're on the wrong side of a dictator like Vladimir Putin, really terrible things can happen. And so I'm very grateful to Constantinos for this report and his effort, and for the rest of the team for all the good work you're doing. And like many other victims, I'm here to support the efforts and the whole initiative. Thank you.
Let us then transfer to question and answers part, and for remarks from human rights defender. We have Ludmila Kozlovska from Open Dialogue with us. She will speak about the most sophisticated way of transnational repression, which is something new, and we have to learn how to fight against.
2 minutes.
Ludmila, it's unfortunately 2 minutes.
Yeah, maybe then we'll focus just saying that for the last 16 years working with institutions and defending hundreds of political prisoners from many countries, including also politically prosecuted lawyers and judges like Anwar Sadat in Moldova, where the regime changed there, but consequences of these political prosecutions still there. And even if you win courts, if you have all apologize for the governments, then still these propaganda attacks, and one aspect which I want to highlight here, how sophisticated different kinds of transnational repression is transnational financial repression. It's when smear campaign, different principal smear campaigns, they affect your financial sources, access to financial sources. You have no bank account, even if you afterwards try to sue bank, there's no regulation which allows you to restore your rights. And specifically with this focus, I hope affected not only human defenders, but also members of the parliament, donors who support victims of political persecution. So we came to the conclusion that it's not only a problem of civil society diaspora, but it's also national security threat. And this is why we were speaking about it in the US, we also speak in the European Parliament, and here basically bringing three main packages of recommendations. First, one of the most important things to understand that transnational repression has to be expanded to national security threats, because it's members of the Parliament, it's EU courts, it's financial institutions who are nowadays heavily under attack and instrumentalizing this repression. Second, we have to have emergency remedy, and this is privacy communication and privacy of payment tools, the crypto assets like encrypted messengers. They should be preserved and they should be neutrally described in regulation. Although right now we see the trend that is perceived as a potentially used by extremists, terrorists, money launderers, and it gives negative connotation to these tools. Third, it has to be a victim approach, and it has to be specific transnational repression task force, but ideally established here in Council of Europe. Why? Because they will be able to collect testimonials like today, but way more with resources, and not only just document individual cases, but look with financial institutions where we, for example, the human defenders have no access, but they will have access to this and collect data to see patterns, and immediately with lawmakers, experts, to provide emergency solutions and rehabilitate these victims. And the most important, do list of the countries, red list those who violated, and green list those with whom this data can be shared. And I will just remind as a conclusion that one of the most wanted right now data and source of I would say at all attacks, it's behavioral data. It's your travel, communication, and financial data. You cannot protect because there is no remedy. Our financial system, our law judicial system not ready for this kind of abuses. So thank you so much for Konstantinos. We worked with him for the last 4 years on this issue as building True Change Coalition and Open Dialogue Foundation, and we really appreciate every single person, member who is supporting us in this work. Thank you.
Thank you, Ludmila. Thank you very much. Dear colleagues, we really run out of time. I will ask Konstantinos to give us a few final words. This meeting has been registered. It will run in YouTube, and also all materials we were speaking about are available to be shared.
I wish this event lasted 2 or more hours, but unfortunately we are running out of time. Okay, we can see that transnational repression can take different forms and methods. We have the raw and brutal methods, as explained. We have the sophisticated, high-tech, the financial methods. We have the disguised methods through the Interpol warrants of arrest or international or European arrest. All these methods have one scope and tend to seize voices. We are in Europe privileged yet to have our voices, and we have to appreciate that we're allowed to speak freely. So what comes as a result of this situation is that we have a voice. We have to raise our voices against not only transnational repression, but against injustice, against all means come from dictatorships and all these regimes. So let us raise our voice against injustice and do not give up expressing ourselves. Thank you.
Кто хочет вопросы, можете пообщаться там, на коридоре, да?
So, you will be free for
I
15 minutes.
have to go.
The rapporteur is here with us for an informal conversation. Who else have questions to the experts? You may speak informally as well. And again, I repeat, all materials about these cases, including video materials, are available if you speak to me, I can send to everyone.
Thank you.
Yes, there is coffee and water outside. We can continue our informal meeting after this formal one, and we have journalists whom I know they are really craving to address questions.